Hi, everyone. Good morning and welcome to the 2024 Data Protection, Privacy, and Cybersecurity Symposium. Today, we're talking about privacy and competition law. My name is David Spratley, and I'm a privacy and technology lawyer here in Vancouver. I'll be moderating today's discussion about the privacy and competition law issues. I'd like to acknowledge that DLA Piper's Vancouver office, where I'm based, is situated on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. I'd also like to acknowledge that you are joining us today from many places, near and far, and I acknowledge the traditional owners and caretakers of those lands as well. I'd like to introduce today's speakers. First, we have Kevin Wright. Kevin's a lawyer in our Vancouver office. He's an experienced competition law and class action defense lawyer. He's the chair of our firm's Canadian International Trade, Regulatory, and Government Affairs Group. Kevin's practice covers all aspects of competition law, including price fixing investigations, merger clearance, abuse of dominance investigations, advice on marketing and distribution practices, compliance programs, and defense of criminal charges. Our other speaker is Stephanie Kolla, a lawyer in our Toronto office who focuses on privacy law and commercial litigation. Stephanie has been in-house legal counsel at an international performance luxury brand, where she managed international privacy compliance issues and advised the business team on a range of complex data protection issues. Today's session is to discuss the intersection of privacy and competition law. Many of us who are privacy lawyers and are used to looking at and analyzing the collection and processing of personal information purely from a privacy lens, but there are other lenses people can use that are relevant to that activity, and competition law is one of those lenses. Today's discussion will start with a brief introduction to the competition law framework. We'll discuss deception and dark patterns, enforcement and remedies, information sharing among privacy and competition regulators, and we'll leave some time for questions at the end. You can submit them to the chat, and we will address them at the end. And just so you know, if you submit a question, only you'll be able to see it. When you and us will be able to see it. So again, feel free to throw in your questions, and we'll address them when we can. With that in mind, Kevin, I'll turn it over to you.
Thank you, David. And I think you control the slides. So welcome, everyone, and thanks for the kind introduction from Dave. So as he explained, my contribution to this panel is I come at this as a competition lawyer. And so I'm going to kick this off by talking a little bit about what competition law is and how it might intersect with privacy. And then we'll dive into some of the places where they overlap, and we'll go, Stephanie and I will go accordingly. So first of all, there's various ways in which data and privacy considerations can intersect with competition law, and the core of it is that data is becoming a critical area in many businesses and even beyond businesses, or primarily about the aggregation and use of data. But the point of competition law is that it deals with how parties compete and participate in economies, and so the way that the parties treat their data and how they compete in collection and use of the data is going to be relevant to assessing various sorts of conduct, which I'll come to explain in a minute, including mergers, agreements amongst firms, and abuse of dominance. And one of the other realities is that maybe that the ability to collect data or use the data become an important input. And so if you look at vertical relationships, it may be that someone holding data has an ability to hold up others, or the ability to acquire that data fresh may become a barrier to entry into a market. And then another thing to consider is, this is a very hot topic, is that the ability to share information and data may raise issues about criminal price fixing or other forms of illegal collusion. And then finally, but not least, because this will be a highlight of today's seminar, one of the things that comes up in competition law, besides the competitive analysis, deals with making representations to the public, and it overlaps with other areas of the law. But there's a question about whether the parties are being, how they treat their data and how they explain to the users, including consumers, how they're going to use their data. So whether it's going to be used, how it's going to be used, how privacy will be respected. Those statements are critical, and if consumers or others are misled, that raises questions about whether it's deceptive marketing that it leads to remedies. Next slide. So next slide. So yeah, so here's just a very quick background on competition law for those of you who might not be familiar with it. First of all, the Competition Act is our competition or antitrust law statute in Canada. It's federal law, and you should assume it applies to virtually all business activities. So if you're in business, assume it applies to you. The purpose of the act is to promote competition and efficiency in the economy, and it's enforced by a federal agency known as the Competition Bureau. But there also is significant room for private enforcement, and that's only going to be getting more progressed and pronounced, as I'll explain in a minute. But one thing to keep in mind is the Bureau is not a regulator as such. They're not a decision maker. So the Bureau investigates much like police would investigate crimes, and then the Bureau can either bring cases or in a criminal situation, they can recommend to the public prosecutor's office to bring a case to the court for enforcement, and the courts are ultimately going to adjudicate and decide. The Bureau has in recent years recognized the importance of digitalization of the economy, and they now have a digital enforcement intelligence branch, which applies not only to how people use data, but also the Bureau's own use of data for the purposes of investigating. And the other key highlight of the Competition Act is that we've just gone through in the last 3 years a series of what we might call generational changes to modernize the law, including taking into account issues of the digital economy. And this goes well beyond today's seminar, but if you're not familiar with these changes and you're in business touching Canada, you really should get better background on those changes. We're seeing several new provisions, a reformulated test for key provision, the abuse of dominance, and dramatically expanded private enforcement, some of which has happened already and some of which will come in effect next June 2025. And also, as we'll hear today, really big potential monetary penalties that are going to change the landscape in the calculus. Next slide. Now, just as a high level about competition law, a number of the provisions in the Act will invite the tribunal, the competition tribunal, to make an assessment on an application about markets and the nature of competition. And that makes sense because the Act is all about promoting competition and identifying conduct that might hurt competition or might block it. So you'll see that one of the key things that keeps coming up in the Act is whether the conduct, it could be a merger, it could be agreement between parties, a civil conspiracy, or potential abuse of the dominance, where the question is the conduct likely to substantially lessen or prevent competition? And there's a few other provisions where they use a similar formulation, but the question is whether the conduct is likely to have an adverse effect in competition. And the point here is that it's a pretty fluid process where a lot of different factors are considered, and what's come to be is that where once upon a time the standard view of competition law was that things like privacy really should be dealt with only by privacy legislation, it's come to be accepted that a dimension of competition is how firms compete over the respecting of privacy. And of course, that may go beyond merely complying with privacy legislation, but in a sort of substantive way. I mean, firms will distinguish themselves by saying, we provide really good care and concern for your privacy, and we're going to give you options to control this. And unlike our competitors, we do a better job, and therefore you should use our product. So that's a dimension of competition that's becoming more recognized. And to wit, one of the amendments that was made, a couple of the amendments were made in the recent round of amendments, was to recognize in considering mergers and civil conspiracy, which is usually going to be reserved for things like collaborations, like joint ventures, to actually consider both price and non-price competition. And that would include things like quality, choice, or consumer privacy. So we now have that actually in the legislation itself. Next slide. Just want to touch briefly about abuse of dominance. Abuse is the type of provision where control over data will often rise to issues of potential investigations and controversy. I'm not obviously going to go into a deep dive on abuse, but just highlight that abuse of dominance, sometimes called monopolization in other jurisdictions, arises in situations where you have a firm that can be considered dominant in a market. You could also have cases of joint dominance where two or more firms are jointly dominant. And the key point is that if you're in that situation, and I just point this out, you might be in a fortunate position where your business might be considered dominant. and then you're going to want to be aware of this provision because it's going to have also all sorts of carry-on effects. You may be in a industry where another firm is dominant, and that may also be something where you'd alert to what options or remedies they might have if they're acting improperly. So the point here is that if you have a dominant firm, it's not illegal to be dominant, or but if it then engages in what's known as anti-competitive practices, and that's basically conduct that's intended to have either a negative effect on a competitor or an adverse effect on competition. So if you engage in that, or you engage in conduct which is likely to lessen or prevent competition substantially, then there's a basis for a remedy to be sought under the Competition Act. And if you have both of those things, both the intention or the purpose and the likely effect, then it opens up even a host of other remedies, including potentially significant monetary penalties. Now, the point with respect to data is that the collection and use of data and how it may be accessed will raise potential cases, abuse issues if someone is dominant. And another thing to consider, and this is sort of the flip side, because it's always a bit of a complicated or granular thing, is that you may have situations where a dominant firm seeks to defend its conduct, having regard to its obligations for privacy, whether a required privacy under law or otherwise. To give an illustration, there was a case a few years ago before the competition tribunal where it was against a trade association comprised of realtors. And essentially they operated a system of multiple listing service, and they would set rules about how the members would use the multiple listing service. And there was issues that arose about different business models, different realtor firms that wanted to use and make data that was collected from the MLS in a certain way. And in the course of that hearing, because there was a hearing about whether that was abuse of dominance by the association that ran the MLS, the issue came up as to whether there was a basis to defend the conduct on the basis that they had to comply with the privacy interests of people who provided data. Ultimately, on the facts of that case, that was rejected. But I simply alert you to the fact that it's a complicated situation. It may be that even in good faith attempting to comply with privacy laws might raise issues if you're in a dominant position. You probably should be thinking about that and taking advice. Next slide.
Right. Thanks, Kevin, for that. And thanks, David, for the wonderful introduction. I think that's a good lead into what is one of our main themes during this panel, is really talking about dark pattern practices. And we see this as part of this intersection between competition and privacy. Just as a general statement, I think we all know dark pattern practices are, they're tricks that are used on websites and on apps that make you do something that you didn't want to do or you didn't intend to do. We have a few examples on this slide. This is just a short sampling. There are others, but these ones we thought are really important as far as privacy and competition. And although you were speaking about dominance and using privacy in that case, in some of these cases, you can see that they run, there's tension between them and they run against each other. So, one of the ones is pre-selection. I think we all know what this means. A great example is a cookie banner where you're presented with, the option to select all or to confirm your selection. And when you go to confirm your selection, everything is already selected for you. And really the pre-selection is, it's a default option that influences your decision, although it's, not much friction to change the slide over to, to deselect. The pre-selection isn't, makes it easier for the user just to make a decision that perhaps they ultimately wouldn't have wanted to do. The second example is nagging. And again, I think a great example here is with cookie banners, where, when you first get to a website, you get the cookie banner, and perhaps you decline all, and then you move to another page on that site and the cookie banner pops up again. And it's so annoying to the user that eventually they're going to make a choice that they would not have, or they had not initially made. And so it's just a persistent interruption that requests you to do something that you don't want to do. The second example we have here is confirm shaming. This is really getting at your emotions to manipulate you to do something that, you wouldn't want to do otherwise. And, a good example of this is perhaps you go to a website, you want to sign, or that you're asked to sign up for a a newsletter, and ultimately the rejection button says something like, no, I don't like great news. Whereas a simple no would be sufficient, but that's really trying to like tug at your emotions. Or another example is you're presented with a 10% discount code if you leave your email address, and instead of a no for that discount code, the text is something like, no, I prefer to pay more. So again, it's this idea that the language that's used is really trying to manipulate you into doing something you wouldn't otherwise do. And then our final example here, which is really also, I think, very pertinent for the competition aspect, is this comparison prevention. So it prevents the user from being able to easily make price comparisons, or it prevents the user from switching to a different competitor. Next slide, please. So the dark pattern practices, when we're looking at the Federal Privacy Act, which is the Personal Information Protection and Electronics Document Act, there isn't currently a express provision that prevents or really makes it clear that this type of practice is prohibited. Just as an overcap, I'm sure we all know PIPEDA sets out the ground rules for private sector organizations involved in a commercial activity and how they can collect, use, and share personal information. This is a federal act as well. So under PIPEDA, we have section 6.1, which talks about valid consent. And, case law has really determined that valid consent is an individual's consent will depend on their understanding of what they're consenting to. There are a few principles under PIPEDA that talk about, consent cannot be obtained through deception, and that the personal information cannot be collected by, unfair or unlawful means. I think that the key point here is that, an individual who signs up, for example, our example of the 10% off in exchange for their email address, they understand what they're consenting to. They understand they're giving their email address and they're getting 10% off, but they might not consciously understand that they were manipulated, or it was sort of misleading or deceptive for them to have signed up for that discount because of the language that was used to obtain that consent. So under PIPEDA, though, there really isn't a express prohibition on these sort of dark pattern practices. Next slide, please. I think, as most of you also know, currently, the federal government has attempted to reform the federal privacy laws. And this is through Bill C-27, which is the Digital Charter Implementation Act. There are 3 different sets of legislation under this bill. For our purposes today, we're really just focusing on the Consumer Privacy Protection Act. This is a quick status update on it. It has passed second reading in the House, and it's before the Standing Committee on Industry and Technology. I think one of the interesting things under the CPPA that's going to be totally different than what's under currently in PIPEDA is the this section 16 here. It's expressed that consent cannot be obtained by deception. So the organization has to obtain. It cannot obtain or attempt to obtain an individual's consent by providing false or misleading information, and it can't use deceptive or misleading practices. And it will expressly say, the proposed language expressly says that any consent that's obtained through these circumstances would be considered invalid. And it's interesting because I think that this is going to really expressly prevent the use of the dark pattern practices for obtaining valid consent. So again, it won't be, the focus won't be on the individual, and if they're understanding what they're consenting to, it'll expressly say that, for example, in the nagging situation where you're constantly being asked to consent to all cookies, that type of practice will be expressly excluded under section 16, and it won't be considered valid consent in that regard. Next slide, please. I think we'll pass it over to you, Kevin.
Okay, thanks, Stephanie. So just to come back to the Competition Act, the Competition Act has essentially both criminal and civil provisions, and it turns out that with respect to deceptive conduct, there is both a criminal provision and a series of civil provisions that will address that conduct. And so, for example, this is the reference here is sections 52(1), which is a criminal provision, and 74.01, which is a civil provision, essentially, and I'm paraphrasing, representations that are made to the public to purpose of promoting a product or business interest. And if they are false and misleading in a material respect, that can lead to enforcement conduct. The key distinction between the criminal and the civil is that in the criminal, you need to have a special sort of intention, knowingness or recklessness as to the fact that it's false or misleading in a material respect. And as a matter of enforcement, generally the Competition Bureau will prefer to use the civil provision for various reasons, including ultimately the onus of proof for the prosecutor or the bureau would be a civil standard, not the beyond reasonable doubt. It's a criminal standard. Essentially, the bureau signaled they would reserve the criminal provision for a really serious, egregious type of conduct, at least from a prosecutional point. Now, a few things to keep about both provisions. You don't have to show, the prosecutor that is, or the bureau wouldn't have to show that anyone was actually misled. So although it's about deception, essentially, and the capability of deceiving, they don't actually have to, bring consumers forward and say, hey, I actually was fooled by this. Another important aspect is that you consider the general impression of the conduct, and that's perhaps consistent with the analysis of dark patterns. It's not simply whether literally you've given consent, but whether in the totality of the situation, the impression that was given or the signals were such that it's likely to mislead. The perspective that it's considered is that of the ordinary consumer of product or service. So there'll be some understanding of the level of sophistication or lack of sophistication of a party. So you could have a situation where there's generally sophisticated users in, let's say, a niche area, where maybe the standard for what's considered misleading would be different, but for many consumer situations, you're dealing with a wide range, and that'll have to be taken into account. And as noted, dark patterns are of an enforcement interest to the Bureau. So one of the things we're seeing now is that, well, this is clearly directly in the wheelhouse of privacy enforcers. We now have overlapping enforcement jurisdiction with the Competition Bureau, and it's something the Bureau cares about. Next slide. Now, I wanted to give a real-world example. There was a matter, it's now a few years old, in 2020, where Facebook was investigated in one of these provisions, and they ultimately agreed to pay a total of $9.5 million. That was broken down to a $9 million administrative monetary penalty and a $500,000 payment in addition, in recognition of costs. So that was by consent. They didn't go through a full hearing, but there was an investigation by the Competition Bureau. And the gist of the investigation or the allegations was that the company was alleged to have made false or misleading claims about the privacy of Canadians' personal information on the Facebook and Messenger apps. And so the allegation of the Bureau was that Facebook was giving the impression that the users could control who could see and access their personal information when using Facebook, provided they made certain selections under privacy settings. But the Bureau went on to say that Facebook did not actually limit the sharing of personal information with some third-party developers in a way consistent with the company's privacy claims. And there were other issues of that. Now, the point here is that there is an example where enforcement was taken, where statements were made about privacy. So it wasn't merely complying with the duties to respect privacy, but the fact that statements were made about how data was used, and it turned out that apparently in some applications it might not have been the case, and that led to the resolution. Next slide. Okay, so I think I'm on still. So just a little bit about what the penalties are, and this is where it gets interesting or scary. First of all, for the competition provision for Section 52 of the Act, you can have a criminal violation of the Act where the general penalty, monetary penalty or fine, will be in the discretion of the court. Now, what that means is that there's no upper maximum. It doesn't mean the fine is infinite. And of course, the sentencing principles will guide what's appropriate in a particular case and have a regard to all sorts of factors, including the severity of the practice, the impact, likely the volume of commerce affected, and various matters. You should also be aware, though, that if there was a criminal prosecution, that individuals who were directly involved in the conduct could be the charge themselves, in addition to the organization, if there was an organization, and they face, in addition to potential fines and other remedies, the potential imprisonment of up to 14 years. And that's a pretty staggeringly high number. Not the sort of thing you would expect to actually see. It's the same maximum for things like aggravated assault. But the point here is that if you're in business, and this is something when I counsel competition clients on various criminal provisions, you can imagine that having an investigation over you, whether you personally violated the law and guilty of crime, and even getting any criminal record, regardless of any duration of a prison sentence, would be really crippling to your ability to function in business and travel and that sort of thing. So potentially really serious criminal consequences. Now, that said, I've mentioned that's not normally how these cases are brought. Typically, the criminal case are reserved for really things like almost amounting to fraud, egregious situations. More likely, what's going to happen is that the Bureau will go under the civil provision, and in that case, there's a number of potential remedies. It's almost a given that you'll have prohibition orders. In other words, if you're engaged in deceptive conduct, there's going to be something saying stop it, and describing what it is, either in general ways or specific things you can't do going forward. It's very common that you'll have to produce, as someone is found liable, will have to make corrective notices and public ways, and likely to get to the attention of people that might have been affected, so they know about what happened and they're able to react accordingly. So if you have a database of users that might be affected by your conduct, you might have an obligation to send out an email or other communication that's been approved by the Competition Bureau explaining what you did. Now, where it gets scary is the potential administrative monetary penalties. And I mentioned at the outset about amendments to the legislation. So it used to be for many years, and it still is the case, that there's a potential maximum fine of administrative monetary penalty of $10 million. And if you've already had an order made against you, so if you're a repeat customer, if you will, before the Competition Bureau and the Competition Act, then the maximum is up to 15 million. That was the law for a long time. And that was also the law in place during the Facebook case I mentioned. I note that they paid 9 million, which is significant. And in general terms, people have commented, and it's probably inspired amendments to say, well, wait a minute. It may be that for some businesses, 10 million is a lot of money. It's probably a lot for most businesses, but it also may be, compared to the potential gravity of the conduct, it may not be enough to efficiently deter or to encourage compliance. So the thinking evolved to say, well, we're now going to change the formula, and we're going to say it's an option. So one option is it could be up to $10 million. Another option is it could be 3 times the value of the benefit derived from the conduct. That's just stopping there. The benefit derived isn't something that can necessarily easily be determined, and this is something that I think we're going to see the law develop over the years. I was involved in a recent major competition conference, putting together a panel where we actually had discussion about what does this mean and how should that be applied. The idea is that benefit derived is that if the business can say, well, if you can say that, well, we got some sort of a benefit because we engaged in, let's say, a dark pattern, and we, for example, got more people to sign up or agree to certain options, what was the benefit that actually would apply to the particular business? So that, and then they're going to say the potential penalty isn't just what you actually obtained, but up to 3 times. In other words, it's saying we don't want you just to get away with breaking even. We want it to be more. And then you can say, well, that sounds pretty bad. But it could get worse, because it goes on to say that if you can't reasonably determine the benefit derived, and let's pause there. If you only had benefit derived or 10 million, then it would be in your interest as a respondent to say, I don't know. I don't think we got any benefit derived. We can't really figure out. No one was paying us a fee. It's not like we collected any fees as a result of the conduct directly. It's too hard to figure out. And if that's your response, the enforcer may come back and say, okay, well then now we'll look at as another option up to 3% of your annual worldwide gross revenues. Just pause there. It may be that you're only based in Canada, in which case worldwide doesn't have any particular inputs, but 3%. I mean, you might be, for example, dealing with only a portion of your business that's affected, and to say that the potential that the company might have to pay up to 3% of all of its annual revenues, not profits, revenues, is staggering. It's even more if you think that it operates on an international basis, as some platforms and others do, where they might start reaching out. And this seems to be inspired by the way that the Europeans have approached competition enforcement. They often have provisions where they'll take on worldwide turnover. And so potentially the numbers are huge. And so it remains to be seen how this provision, which is new and is untested essentially, other than there was one recent case against Cineplex where Cineplex was ordered to pay almost $40 million. It wasn't a dark pattern case, but it was another deceptive marketing conduct case. So we've already seen one very significant decision, way more than 10 million, and we'll see how this evolves. There could be challenges. It wouldn't surprise me to see in a real contested case to see a constitutional challenge. The theory of these administrative monetary penalties is that you should they're not supposed to be criminal fines. Because if it looked like a criminal fine, there's a risk that it might be unconstitutional. So they're always framed not to punish, but actually to encourage compliance. That's the way they say the fines are supposed to be guided. And the other thing to consider is actually how the tribunal or the courts that are applying this provision will interpret it. We've seen a case, as I said, one recent case that was based on actual amounts collected where they came up with a number of close to $40 million based on certain fees that were paid by people that signed up to get movie tickets online. How this will be applied in the case of a dark pattern and stuff where there may be no monetary payment remains to be seen. But take note. Now, I mentioned early on about abuse of dominance as being something that could come into play for use of data and protection of data. I just wanted to point out that it too has had a reformation of the maximum potential penalties. Really, the structure is the same, except if you, instead of a potential maximum of $10 million as one of the tranches, they've now put that as 25 million or 35 million. You've already have an order against you. So you still have the problem of potentially 3 times the value of benefit derived or 3% of the corporation's annual worldwide gross revenues. So some potentially scary things up happening here. Next slide. Okay, just talk a little bit about competition law and the enforcement and the complaint process. So, and this of course is important both in terms of whether you might be the subject of a complaint and also if you are if you have a concern and you think if you're a consumer and there's a concern about conduct of a party, or if you're a business and you're concerned about what another business or a rival or supplier is engaged in. First of all, the Competition Bureau maintains a website, and it's very easy to navigate to their website and find a forum where you can submit a complaint about anything under the legislation, and it will eventually get to the attention of someone at the Bureau. The one thing to keep in mind there is that the Bureau will receive, through many different ways, lots of different complaints in a year, especially in the area of deceptive marketing to get its consumer attention. Bureau has only so many resources, and it's responsible for administering the law throughout the whole country and all the businesses in the country. So as a practical level, when you look at the cases that get brought forward, the cases either brought as an application to a court or the competition tribunal on deceptive marketing, or cases that are resolved where there's an investigation and short of a contested hearing, there's a resolution and that notice of that is given, there's actually remarkably few. I mean, you all can count on one hand the number of cases in a year, at least as it's been. The Bureau will point out that they've had an increased budget and they will be seeking to do more, and they certainly are vigorous in going after cases. And if you are the subject of a Bureau investigation, especially if they decide to contest it, they will pull out all resources because they don't want to lose if they actually bring a case. So on one hand, in terms of making informal complaints, it may get the attention of the Bureau. It may also be something where the Bureau takes it in and they just don't really have a chance to move it forward because they don't have the time or resources, or they make a very preliminary triage decision on how serious it sounded. That is, you could have something that might be the basis for violation of the law, but the Bureau might have to determine, having regard to the number of people affected and the basic facts of the type of thing where they can afford to spend a lot of resources. One thing to consider if you're making a complaint is that you will often reach out to counsel who can help frame the complaint and speak in, I guess, the language, or bring out the things they think will most likely attract the attention of the Bureau. You should also be aware that there is a section of the Competition Act, Section 9, that allows for 6 residents in Canada to make a formal application to force the Bureau to start an inquiry into any conduct that might be the basis of an order under the legislation. And they would have to put a brief together, a supporting affidavit. You're seeing this done more and more, particularly by advocacy groups. So we've seen cases of misleading or deceptive marketing where groups will look at the conduct in either in the whole industry or a particular party, often in industries that are of particular attention. There's a lot of stuff, for example, involving greenwashing, which is a whole nother webinar we could give, where that happens. And there's no reason to think that you won't see this potentially happen in the case of privacy. So if you had serious complaints or issues arising with respect to a company's organization's treatment of data, it may well be that an advocacy group will say to the Competition Bureau, we're going to actually force you. We're not going to just complain. We're actually going to force you to open an inquiry. They can't force the Bureau to come to the conclusion that something was done incorrectly, but it will, up the ante a bit. Now, I mentioned about Bureau enforcement, and the very fact that the Bureau is resource constrained and has brought few cases has had the attention of the politicians and people thinking about the enforcement in this area. So this is one of the issues that was considered as part of the recent amendment process, and there was a big public consultation that led to various amendments. And what's happened now is they are dramatically opening up private enforcement of the Competition Act, including the Part 7.1, the deceptive conduct provision. So it used to be that if you had concerns about alleged deceptive conduct, false or misleading representations, or there's other provisions in that deal with specific issues, that your only recourse was to go to the Competition Bureau and make your case, make your complaint, formal or informal, and hope the Bureau would take a step. Another thing that has happened and continues to happen is that where appropriate, a class action may be brought. And so we defend lots of different types of class actions, and often there will be allegations of a violation of the criminal provision, Section 52 of the Act, which basically prohibits the false or misleading representations that are done knowingly or recklessly, and which I mentioned before. And of course, class actions can be scary because they bring it on behalf of a whole group. It could be thousands, hundreds of thousands, even millions of people that are allegedly affected by their conduct, but they take their life of their own to sort of proceed along. And that is private enforcement where money can be obtained, but it actually doesn't result in any order under the legislation. It's just a question of whether money's paid. Now what's happening is that keep the same. Back on the slide, thanks. Almost there. The new law will say for a number of provisions. First of all, there's a number of provisions where they had no private enforcement at all, and now private enforcement will be alleged. And what that means is that an applicant can go to the competition tribunal, and that's the specialized court that deals with competition matters. And they would have to go through what's known as a leave process, permission. So they'd have to convince the tribunal that it's a screening process. Yeah, we have a legitimate potential application. In other words, there's some merit to it. It's not proving your merit up front, like as if it's the final hearing, but there's enough there. So if it was a bogus case, the tribunal could filter it out. And they also have to show appropriate standing. Historically, the test for where we do have private enforcement already has been a tough go. They've had, basically it's been read in a way to say that it has to be limited to businesses, not consumers, and it has to be limited to situations where, for the most part, where you're significantly affected the whole of your business. So if you had a 20% of your business that was subject to allegedly improper conduct under the law, you would, there's a chance you wouldn't even get standing because they say, well, it's only 20% of your business. The rest of it doesn't affect the other 80%. So they've changed the leave requirement to, on one hand, say it's only enough to show it has a significant impact on part of your business. Or there's an ability of having a public interest test, which would conceivably allow people acting for consumer groups or other interest groups to seek leave and participate and bring the cases before the tribunal. Now, what happens is when they get the leave is that they bring the application just like as if they were the competition tribunal. Competition Bureau, the Commissioner of Competition, the head of the Bureau. And that means that they would be able to seek remedies like the prohibition remedy, corrective notices, and administrative monetary penalties. So it's a weird situation where you can have a private party going to a court, the tribunal, and saying, you should order this party to pay a lot of money. And one of the things to consider there, and we'll see how this plays out, is that if the Bureau brings a case, they usually have, and I'm going to say it probably would stand, and Stephanie will talk about this, if you were a privacy enforcer dealing with their legislation, there's a certain discretion in terms of what's appropriate. Just because there's a maximum penalty doesn't mean that that type of penalty is appropriate in a given situation. But you could have private enforcers getting leave where they want to sock it to whoever the respondent is, and they'll seek the max. Ultimately, it's subject to the tribunal, the court to adjudicate, but it adds sort of dimension to the complexion of how you deal with it. It's not merely, can we satisfy the Competition Bureau, for example, whether our conduct's proper according to the Bureau's guidelines, but the fact that anyone can, in theory, go to the tribunal now. And as I said, with respect to the deceptive conduct provision in Part 7.1 that I mentioned before, you couldn't. Now, effective next year on June 20th, the applications can be brought. So that's just upping the ante. Next slide.
Thanks, Kevin. Now that you have sufficiently scared everybody, listening in, I will sort of bring the tension down a bit to say, currently under PIPEDA, there's, it's not that scary. It's really a name and shame type of regime that we have. So the Office of the Privacy Commissioner, they cannot make enforceable orders. Currently, they have to go, it's assuming very similar under the Competition Act. They go to make a application to the federal court, and how Kevin described it's very similar situation. They also, the OPC can enter into compliance agreements, which is very similar. It's really about corrective action, getting organizations to be compliant, and the theme there, the purpose there is really not about monetary penalties. And as the act currently is, there are really, except in very limited situations that really apply to retention of records, there are no administrative penalties, and we haven't seen any in that regard. And another big difference is you scared everybody about the private right of action under the Competition Act and the changes there. There is nothing similar under PIPEDA. So it's certainly less scary in the privacy world as it currently stands. Although, we do see, there are civil cases and class actions that are brought with respect to privacy. But as you already mentioned, the remedy there is really about the payment of money, and has, the courts in those instances don't have the authority to order certain other types of remedies that you already discussed. However, the landscape is potentially changing. So next slide, please. I'll just quickly, you gave kind of an overview of the, the investigations and the Competition Bureau. When we've looked at the annual report from 2023 and 2024 of the OPC, I guess significantly less complaints. The OPC does manage two privacy legislations, the PIPEDA and then the Privacy Act, which is a government with respect to government organizations. So if we look just at PIPEDA, the OPC received 446 complaints last year, and only 16 of those were well-founded. They resolved 363 of those through the early resolution process, and 42 went to standard investigations. Similar to what you were describing, some of the reasons that they might not continue an investigation really has to do with, is this a well-founded? Is it a vexatious? Does it have anything to support the allegations that are made? When we look, so that's complaints. When we look specifically at data breaches, which, we're not really talking about much in this panel, but just to give a little flavor, there were 693 reports regarding data breaches and the top industries. So depending on who's participating and listening in, the top industries were the financial and telecommunications sectors. And then, as you mentioned in the Competition Act, and as I just said, there were 16 instances last year where the OPC entered into advisory engagements with private sector organizations. And again, those would really be about compliance and corrective measures, really to try to get organizations to get their acts in gear, so to speak. Next slide, please. So there are potential changes if this, if the bill is passed, if the government doesn't shut down. The potential changes under the CPPA are a little bit more in line with what we're seeing now under the Competition Act. So, proposed legislation would permit individuals to file complaints with the OPC against organizations. That's something different than what we've currently seen. Again, that would be similar to private right of action that Kevin talked about in the Competition Act. We also have the commissioner can initiate a complaint if they're satisfied on reasonable grounds. There's a need to investigate, and some of those factors that they'd be considering there again would be, is there an alternative venue where this complaint should be brought? Is there sort of sufficient evidence to pursue the investigation? Is the complaint trivial? Is it made in bad faith? And has the organization had an opportunity to provide a fair and reasonable response to the complaint? And, I think one of the questions might be, if the CPPA is passed and there's sort of these two competing organizations or government entities that have sort of similar but maybe different remedies, who takes over? Who has the opportunity to run with the complaint? And specifically under the CPPA, they would defer if there's a more appropriate, if it can be dealt with more appropriately by another federal or provincial law, then the commissioner may decide, the privacy commissioner may decide not to carry out the investigation. And so in those instances, that would obviously also include the Competition Act, and the commissioner may defer to the Competition Bureau to conduct that investigation. Next slide, please. Similar to what we see under PIPEDA, the commissioner would continue to have the opportunity and the ability to enter into compliance agreements. And again, though, the purpose of those types of remedies and enforcement is really about corrective action and not about administrative penalties or other types of penalties, trying to get organizations to get in line with the legislation and the requirements under that. Next slide, please. And then it gets a little scary, just like you said, under the changes to the Competition Act. So the proposed legislation, the CPPA, would, as it's currently drafted, the commissioner could recommend a penalty for contravention of certain provisions, and this includes, as we discussed sort of at the top of this panel, the section 16, which is that consent was obtained by deception. So in that instance, if the OPC after conducting its inquiry, had determined that the consent was obtained by deception, which could include certain dark pattern practices, then the commissioner can recommend a penalty. Currently, as the legislation is drafted, it would go to the tribunal. The creation of a new tribunal is the second piece of the legislation in Bill C-27. And that tribunal, it would have the power to make and impose orders. Although there's been a lot of discussion and submissions before the standing committee about changing that so that there isn't sort of an extra layer of administration, government administration. And the change, the requested change would be that the OPC, the commissioner itself, would have the power and ability to create orders and impose penalties without having to go to the tribunal for that. And then I think similar to what we see in the Competition Act, and certainly what we're seeing in Europe, is a maximum penalty, which is the higher of 10 million or 3% gross global revenue. And that would be based on the fiscal year prior to the one in which the penalty was imposed. And similar to what you pointed out, Kevin, this is not profit, this is revenue. So it can be a significant penalty that's imposed. Obviously, that's the maximum amount. And I think similar to how the Competition Bureau decides on, or the tribunal decides on the penalties, there'll be a number of factors and principles that are considered in order to determine what that amount is. But to point out that this would be a significant change to the federal privacy legislation, and it would potentially become no longer a name and shame, but name, shame, and pay up. So certainly something to consider, and a sort of a key takeaway if this legislation actually is passed. The other thing I think that is interesting in the proposed legislation is if the commissioner or the tribunal makes a finding that an organization has contravened the act, then individuals, they'll have a cause of action for damages or loss or injury suffered. So it sort of is like a little, go past, sort of express lane, shall we say, to bring a cause of action against that organization based on a finding of the commissioner or the tribunal. And this would be the same, the individual would have those same rights, so same cause of action rights if the organization is convicted of an offense. So sort of another opportunity for the organization to kind of get hit based on their actions and contravention of the proposed legislation. So I think, as we talked about with dark patterns, it can be pretty easy to it can be pretty easy to use some of those deceptive marketing practices and not realize that they're deceptive marketing practices, or that they're contrary to the law, or the proposed law, at least in the CPPA, and get kind of caught up in that. An investigation is made by the tribunal, and perhaps the monetary penalties, or maybe there are no monetary penalties, and it's just a corrective action. But then, individuals, after that inquiry and that finding against that organization, individuals sort of having a little express lane to have a cause of action against that organization. So it's something, if the legislation is passed, and obviously we'll have to see how this all gets determined and how it all plays out, it's just something else to be aware of, that organizations, it might be sort of a multi-pronged attack, shall we say, on organizations based on this proposed new legislation. So I think maybe not as scary as Competition Act, because this is a legislation that's currently before the House and the Standing Committee, and based on where we are in the election cycle, might not get passed before that ends. But something for organizations to keep on their radar if this legislation does get passed, that really ups the ante, I think, in the privacy world, to be a bit more thoughtful about some of the what might seem like benign marketing practices. Next slide, please. And then this is our final topic, and I'm sort of mindful of the time. We're at 4 minutes, and there may be questions, but we just wanted to highlight some, there's a lot of overlap, and we've talked a lot about the overlap today, and, the fact that it's a bit more scary under competition law, and could get scary under privacy law. Just talking about how these two, how the two different government organizations share and exchange information. So currently under PIPEDA, there is this section 20, it's a confidentiality provision, and it's generally understood that this section restricts the nature of the information that the privacy commissioner can share with the Competition Bureau on enforcement matters. Now, there is an opportunity for the commissioner to disclose certain information, but that's in instances where the commissioner has given permission to intervene in proceedings under the Competition Act. There's been certainly some discussion in the proposed changes under the CPPA to expand this this provision and the ability for the two commissioners to exchange information more easily. And there certainly have been some discussions about the fact that under both of the laws that the commissioners can share and exchange information more easily with international organizations, and it's much harder for them to share internally here in Canada. Next slide, please.
Hi, and I'll just pick up on that theme from the Competition Act perspective. So, as you might expect, the Competition Act has a provision dealing with information that the Competition Bureau obtains in the course of its investigations, formal or informal. And the basic rule is the Bureau cannot communicate information gathered except in certain limited situations. And one of those couple of situations are to provide it to a Canadian law enforcement agency, or otherwise there's a more broad exception for the purpose of administration or enforcement of the Act. So in practical terms, the Bureau does share information with other enforcement agencies, and they have relationships with other Canadian enforcement agencies, including the CRTC, and they often will deal with their colleagues that are enforcing competition laws in other jurisdictions. It's a complicated issue, and when it's allowed, and when the Bureau says it's allowed, and when it should be allowed, those are issues probably for another webinar. But the point here is this: is that. And this is really important as you see, say, encroachment by the Bureau into privacy issues that might have once been the domain of privacy enforcers, that you're going to have concurrent administration and investigations, and it cries out for coordination, especially if it's in the same country. It seems then we have limits now that might be addressed, or at least partially addressed, for Bill C-27 if it comes to pass. And I think, in just a sort of a high level theme, because we're getting to the end here, I expect that we will see attempts to coordinate between the Bureau and the privacy enforcers, because I don't believe they'll want to double up on remedies where it's not appropriate. There's always that double sort of whammy risk. I think you will see coordination as you go forward. By the way, one of the questions I did see, the only question I've seen, if there's any other questions, please, almost at the end of the time, is that whether a copy of the slides will be available, and we'll make sure that if you sign up for this, that a set of the slides gets sent your way. So that's my bit, subject to any further questions or comments from Dave or Stephanie.
Nothing for me, Steph, unless you have anything. I think we can wrap it up, but thanks everyone for coming in. And again, interesting topic. Got to be aware, right? We sometimes have privacy blinders on, but there's other regulatory regimes out there that can touch on the same areas that we dwell in as privacy people. So thank you for attending, and have a good rest of your day.